testimony on that bill. Now, the last bill that we have here is Delegate Carter. Bring up whoever you'd like, Delegate Carter.
Thank you for calling the bill, Mr. Chairman. Committee, first let me start by saying I appreciate you and share your fatigue in the long hours and number of bills that we've heard at this point in session. We've heard a multitude of bills and testimony regarding law enforcement and bills that would help us fix the relationship between some communities, individuals, and law enforcement. We've heard from mothers and families and victims of brutality. We've heard from law enforcement that pretty much claims that, you know, there may be problems, but the solutions do not lie in altering the Law Enforcement Officer Bill of Rights. If we don't take any action at all, I think that is a great failure on our part. This bill is a bill that would be designed, and I would think that possibly law enforcement on our community members would like this bill, because actually what it does is it would be an assistance to officers that wish to report on incidents of misconduct or brutality or excessive force. Recently, a high-publicized case in Baltimore City of an officer, Joseph Crystal, and there is an article that I have, I'm not sure if it was distributed, that talks about his situation, but basically he simply reported an incident of excessive force, of brutality to his superior officers. He was warned at that time to not to remain silent and not go any further. His integrity pressured him into going further, and as a result of that, he was retaliated against. He was harassed, horribly harassed, and mistreated and disrespected by fellow officers, and ultimately he currently has a lawsuit against, believe it or not, Baltimore City Police Department. So this bill is simply a protection for whistleblowers. I understand that there's already protection in our laws for whistleblowers. This is directly related to public safety, and it basically would just provide greater protection, greater notification for officers that wish to not remain silent in the face of misconduct. I'm pleased to be joined by Ken Williams, who will tell his story and why this bill would be effective. He is former law enforcement, and he actually was the person that reached out to me about this specific legislation that is modeled after another law, I believe, in Arizona, and also Sarah Love from the ACLU. Thank you.
Thank you. My name is Ken Williams. I'm from Boston. I came in by flight this morning, so I left around 5 o'clock in the morning, so forgive me if I look a little tired.
Yeah.
Nonetheless, I mean, I'm proud to be here because this is an interesting bill. I've never seen anything like it, actually. I did 15 years in homicide in the state of Massachusetts, the city of Brockton. One of the things that ended my career was being a whistleblower. It wasn't the fact that I was shot at a couple times in the line of duty or that I had to defend my life in the line of duty. What ended my career was actually reporting a wrongful arrest. A gentleman that was one morning, without my being present, wrongfully arrested, had his rights violated, and the Constitution was not upheld during his arrest. I came here today because in addition to this bill, House Bill 1187 being a good cops bill, it actually does what everyone outside maybe this great hall is asking government to do, which is to have a reliability standard within policing to allow cops to police cops. And in order to have that mechanism take place, House Bill 1187 is not addressing a 14th Amendment violation issue. It's not addressing a First Amendment violation issue. What it is addressing is notification, notice. Police officers are highly trained. They're given specialized training on criminal procedure, criminal law, how to go out and police communities And what this bill is addressing is that when a police officer sees corruption, misconduct, abuse of authority, law violations taking place in their presence, this bill is saying when that officer approaches someone within their agency to notify them of a crime or an administrative issue that took place in their presence, that they're to be given notice of the things that may follow to put them on notice of their First Amendment standing. And what that also means is that the officer can then make necessary adjustments to determine whether or not he trusts the people that are within his agency to actually take a serious criminal misconduct issue or an administrative issue and not use it against them in the form of retaliation later on. So this particular bill is a very, very interesting bill because not only does it afford a certain amount of notice, it also could potentially lower your liability issues with respect to a police officer later on filing a First Amendment retaliation claim against you, as well as taking out the fact that the officer was never trained on civil action matters, civil rights matters that relate to them as an employee working for the employer. So this is a very, very powerful bill that simply is probably all of a couple pages, but the pages themselves, just for an example, and I don't mean to go off track, I was in law enforcement for many years, and I've never, ever in the time that I've served and protected citizens, I've never seen a police officer be honored for blowing the whistle. Never. The simple fact is that when officers blow the whistle, they then have informal and formal things that happen within the organization. The formal things are you can be subjected to all types of nasty things administratively. The informal stuff is you may not have backup show up when you wanted it, when you needed it, because all the other folks in the institution turn their backs on you. So policing is not like any other job on the planet because it does rely on other individuals who have certain powers vested in them and granted to them by the citizens. Earlier today I heard one citizen from this great state try to remind everyone that the taxpayers actually support everything that is in the government institution. And I want to also add to that. Title VI under the Civil Rights Act of 1964 is a powerful tool to leverage against anyone that accepts federal grant money but then decides to go and violate the tenets of the law, the federal law, and become discriminatory in nature because you sign off that you're not going to do so. And the possibility of losing federal grant monies is something that should be of concern, but also triple damages being awarded back to the citizens, the taxpayers, for institutions, police institutions, educational institutions that are discriminatory is a reality. I myself in the state of Massachusetts have filed a False Claim Act as a relator, a QTAM whistleblower against my own agency because I found it necessary to use the weight of the federal government and the Department of Justice to investigate the things that I tried to bring forward in my own institution that they weren't willing to listen to. That's playing itself out in federal court right now. I've also had to file a Section 1983 First Amendment retaliation claim against them because my 14th Amendment, my First Amendment, and my civil rights were violated under the color of law. Good employees should not have to go and worry about their jobs simply because they open up their mouths and tell the truth. Sometimes cops do screw up. Some do deliberately, some do intentionally, some, unfortunately, don't deserve to be in the uniform. HB 1187 is the freshest start to try to afford good cops, good legislative powers to protect their rights. Thank you.
Good afternoon, Delegate Rosenberg, members of the committee. My name is Sarah Love, and I'm here on behalf of the ACLU of Maryland. The ACLU has a long history of supporting and representing whistleblowers, as well as supporting whistleblower bills and laws. We believe that a democracy and a civil society must allow people to come forward and report violations of the law and threats to public safety without fear of retaliation. So on one level, HB 1187 is simply another whistleblower protection bill that we would be here to support. But it is in fact so much more than that. Most of you in this room were here with me for 9.5 hours last Thursday, hearing 17 bills about police practices. We heard stories from across the country, across the state about disrespect, beatings, killings. What we didn't hear was stories about officers reporting fellow officers about their misconduct. We should hear those stories. As the gentleman to my left said, we should be awarding those officers medals. We should protect police officers for standing up for what is right. We should enable, encourage, and facilitate officers who respect their badge and their oath and their responsibility enough to report a fellow officer who violates the law. And for these reasons, we support House Bill 1187. Thank you.
Thank you. My name is Matthew Fogg. I'm a retired Chief Deputy United States Marshal, and I'd like to thank this Judiciary Committee for allowing me to be able to speak. I'm here to speak in favor of this bill, mainly because of the fact that I myself blew the whistle on corruption and discrimination behind the blue wall of silence, and I know what I was told by other law enforcement officers. Whatever you do, don't go forward with that. Don't take on the Justice Department. Don't take on law enforcement issues. Because, Fogg, let me tell you something, man. These guys got the means, they got the ways and the skills to get you hurt. And first, I didn't believe them until one day I'm making an arrest right here in Maryland, in Baltimore, Maryland, on a dangerous fugitive stakeout, and my counterparts left me. We ended up arresting these guys, 2 heavily armed suspects, took them in. And when I asked management, and this was after I filed my complaints and everything, when I asked management to discipline these guys, and I was the inspector in charge, he asked me to let bygones be bygones. Ladies and gentlemen, what I'm here to tell you is that when you're talking about whistleblower protection, this bill is a great step in the right direction. It's still far not enough. But any law enforcement officer that's coming up here testifying to you today in support of not having this bill is, trust me, is in a system that they're in denial. Law enforcement officers that come forward, anytime the U.S. attorneys, the district attorneys, any of us, we understand DEA agents have done it all. We understand in order to be able to do our job, we need people that are going to speak out, who are going to come forward and talk about what happened on the inside. The same way with law enforcement. This is a light bill. This isn't that difficult. The main things in this bill that when it says have an independent body by the district attorney, by the DA's office to be able to investigate these complaints is very important, because the police cannot do it themselves. I went all the way to court, and a jury ruled that my rights had been violated in 13 out of 14 claims. That was in federal court. And today we got a class action going, and we're still fighting against the internal retributions and retaliation that other officers run into when they speak out. You have to protect those officers the same way we do as a U.S. Marshal. We have a witness protection program. That program is designed so that we can get people in the reference group to come forward and be able to help us prosecute these cases. The same thing you need in law enforcement. Matter of fact, you need it more in law enforcement. So I can tell you here today, any law enforcement officer that comes up here and tells you we don't need this bill, they've already understand that they're trying to get promoted, they're trying to move their careers forward, and they're trying to go to party line. It's time for change. This bill represents the change that we need to be able to change some of the the culture that we already see today that is in place. ACLU did their report. They showed all of the various disparities in law enforcement. These disparities are there. We know they're there. We as officers understand. We talk about it all the time. Look at the disparities. We see what we're doing. But everybody says, don't speak out against it. Keep your mouth shut and go along and get along until it happens to one of your children or somebody that you know. Thank you very much.
Thank you all for your testimony today. For those of us who are we're on the lawyer side as opposed to the police side, I think it's something that a lot of us have heard watching television or whatever, is that blue wall and the internal guys who do look and see if there are police misbehaving seem to be the outcasts. And I think you're absolutely right. Something needs to be done. And I just wondered if there's some reason that this seems to be more prevalent in the law enforcement.
Right.
Because I know other places they don't like whistleblowers, but from what I understand, it's a little bit more serious within law enforcement.
If you might, I'd like to take a stab at that. Law enforcement is a command and control environment, the same way the military is. So everything is, from the top down. And so you realize it's just like we're all marching up the wrong side of the street, and somebody says, why are we marching up the wrong side of the street? That's it for your career. You don't question it. This is the type of society that when I say step over there, I mean for you to step over there. Now, if that goes wrong, which it does in law enforcement, it affects us as the rank and file the same way we expect for citizens to do what we tell them to do. So that's the problem, and that's why it's in law enforcement. And the problem is, it's a secret wall of silence. It's a secret society because we can't even say it exists. We had the chief of police just recently, Mr. Ken Williams here, asked a question to the chief of police over the president's task force. Asked him the question right on. It was Harvard University, asked him the question right on TV, said, how do you deal with whistleblowing cops? You know what he said? Unless there's critical mass from the other cops, there's really nothing we can do. I was horrified when I heard that answer, because really what that was saying was, keep your mouth shut and go on. If they hit them 10 times and they only should have hit them one time, just turn your head, Fog. If they plant the drug, they say the drugs on when the drugs went on, and I've seen this happen all across the country. So it is real.
And it sounds to me like, from what you're just
one of the things perhaps that is creating this sort of tension between the citizens and the police is the fact that you really don't have an avenue to weed out people who are clearly going above and beyond and shouldn't be.
I'd like to answer that as well. Part of the problem is the policies and procedures in law enforcement, the way that they're written, is that loyalty to the institution is by none the gold standard. The policies and procedures do not permit, in paper, in writings, do not permit an officer to go outside the police bubble with information to the public. So if the officer, for instance, there are plenty of court cases in the appellate court that address First Amendment retaliation. If the officer, as a police officer in uniform, sees an egregious act, reports it up the chain of command, but then later on summarily is terminated, constructively discharged because the person has gone against the grain of the blue wall of silence. Now that person, the former employee, is fighting against the First Amendment clause that the city, municipality, the police department uses against them to suggest that they didn't operate outside the bubble of being a police officer, that they did so with a duty. But here goes the problem with that. If it works so that you have a duty to go and report it up the chain of command, and you have these challenges to the First Amendment later on if that person chooses to go and file a civil action against that, to go and challenge it. Why isn't it being held accountable as a duty to act to report the egregiousness of fellow officers? You can't have it both ways. You can't have it both ways. So the policy and practices that are being instituted across the United States are harming good citizens that are hired doing the job of police officer, because many of those citizens that do speak up are former law enforcement officers.
Thank you. And thank you for coming to testify today, especially the gentleman who came from out of town. I was wondering if you, and I don't know if this might be more appropriate for you or for Delegate Carter, just explain why you think this statute is necessary when we have the EEOC, where people can seek redress or people can go file in civil court. So I'm wondering, why the specific need for a statute.
What was explained to me actually in part by Mr. Williams and other officers that I talked to that are not present testifying today, is that just simply having the policy and the notification and having this made part of the public safety article, which would require the law enforcement agencies to share this information and inform the employees, the officers, of their rights here, would be a great help in urging them to come forward. And this would also help to educate them as to what the impact could be. So that a great part of it is, I suppose, designed to simply change the culture within the department to be more encouraging for officers to come in and speak out, which report on misconduct.
Exactly, and if I might add, the EEOC is after the violation has already occurred, after the officer has been retaliated against, and that officer is bringing the claim. This is up on the front end. So it gives that space of freedom for the officer to come forward, because there shouldn't be retaliation if this were to pass.
Right. And just to follow up, we may not want to file an EEO complaint or any complaint. We just may want to say he hit him 10 times and he shouldn't have hit him 10 times, or they're doing some procedure that we need to stop. We're racially profiling. We're only stopping the black speeders. We're doing something that change it. Like I just spoke to the chief of police about how they're taking these young men and putting them on the side of the curb handcuffed. But when I went to an elementary school and I asked the kids, I said, what do police do? You know what the kids told me? They make you sit on the side of the curb in the handcuffs. That's what the District Heights Elementary School. So I said, Chief, you need to stop that practice. Put them in the vehicle or get them off the scene, but don't let them sit out on the curb in handcuffs. Then next day I ride right by as a group of young black men and they were sitting in the snow. And I waited for it over, and I spoke to one of the gentlemen. He was all upset, angry. He said, man, they made us sit in the snow. He said, we told them we didn't want to sit out there on the ground. He said, sit down. He said, we didn't want to get shot. So what I'm saying is there's a lot of policies and things that, now who's going to go and tell that chief inside the Prince George's County Police to stop doing it? I went up and told him to stop, because I'm not I would have told me had I been a PG County officer. But the bottom line is that's your career. So we're saying we need stuff that can protect us. This is really lightweight stuff here. It's really not that difficult. But the bottom line is I think it opens the door to say to officers, here, these are your rights. If you do see something and you want to report it, you have a right to do that, and you have a right to do it free of retaliation.
I just want to add to that as well. The gold standard is let's say, for instance, if I'm an expert witness, I run a wrongful death consultancy business as well, so I testify in other jurisdictions regarding wrongful death. The Daubert standard in court is the gold standard in terms of looking at an analysis, having an analysis of methodology. The police profession is broken right now because it doesn't have a reliability standard. The FOP and the other officers are worried because instead of it being Joe Blow citizen on the street corner challenging their credibility, a cop challenging someone else's credibility has a tremendous amount of weight.
Yeah.
So if we're going to talk about changing, reform, accountability, justice, we have to look at the fact that giving those cops that are seeing things that are happening in front of them, some young cops, some old cops, but they don't have, they fear retaliation, because retaliation is a reality that we have to go and face, happens every single day. Also, I just wanted to also point out the fact that the whistleblower Dodd-Frank bill each year, the federal government receives billions of dollars from whistleblowers around the country who are courageous enough in the medical field, who are courageous enough in the pharmaceutical field, who come forward with insider information to offer the federal government that these things are taking place that the government would not have known. So there are whistleblowers everywhere. But what my point is that in the police profession, 2009, I was honored as the top cop, one of the top cops in Massachusetts. In 2010, based on the fact that a man was wrongfully arrested, called African Jungle Bunny, kidnapped off of a city street, I was constructively discharged. My career came to a crashing end. That's the reality.
Thank you, Mr. Chair, and thank you all for your testimony. I think in a year where we're looking to pass, well, I hope we pass the False Claims Act that has similar whistleblower protections, some similar protections. I just had some quick questions about some of the technical details of the bill and then whether this would apply. I know it's a prospective thing, but how far back retroactively would this apply after its potential enactment? Two is on page 4, subsection C, line 24. So some of the civil remedies, $5,000 for each instance of retaliatory action. Just wanted to know where that number came from. And third, I wanted to discuss the burdens. On same page, line 416, and some of the implications of what those burdens are. So I guess we can start with prospective, retroactive, and then work away from there.
Okay, he's first.
So this is basically, does this apply? How far back? Can it reach back, or is it only
That was a budget question, so
Yeah.
and now
Sure.
it's prospective, so it should be whenever the law would take effect. Usually it doesn't go back past that date.
Okay. Yeah. So just want to know if people could use it for something that happened last year.
No.
Just to clarify, because that was one of the some of the whistleblower protection. And then two is the $5,000 for each offense. Are there other states that have similar language to this, or where's that number?
I asked that it be drafted specifically after other states that had this, and so I know that there are several, but the one that I think this is resembles most closely is Arizona's law.
Cool. So this is not novel. This is something that's done all across the nation. And then third, the burden. Preponderance of evidence that the disclosure of this information was a contributing factor for the person making the complaint or seeking protection, but then that shifts the burden for clear and convincing to the department. Can you talk a little bit about the implications of what those burdens mean?
Would you?
I'm gonna think.
I think it's more substantive than procedural.
Right. Can I just take a look?
Just basically.
I just wanted to answer a couple.
Sure.
I heard a couple of your questions. Under the federal law for the False Claim Act, it's actually a 6-year statute of limitations. It can go back as far as 10 years if the federal government joins the action.
Yeah, and we're struggling with that with our False Claims Act from Maryland right now, and I'm for it.
Right.
So, and
I just wanted to answer your statute.
No, yeah, I got you. Yeah.
The other question that you had, because you have a state discrimination law, and it kind of varies depending on which county you're in.
Yep.
You also have an EEOC that if a person dual files in this state, they get the benefit, I believe, of 300 days. So I would think that your statute of limitations for the time that a person realizes that they're being a victim is probably if they dual file 300 days.
So my point is, this isn't a huge impact on any of that.
No, this bill, my understanding of this bill, my interpretation of the bill is that I would like to see this bill shared at the police academies, not just at the time when a person brings forward information of egregiousness, criminal activity, misconduct, abuse under the color of law. This type of bill should be a training module at the police academy so that young recruits are policing the agencies. That would be my suggestion.
And that would coincide sort of with the EEOC sort of regulation that we use on the federal side, because we're told about our equal employment opportunity rights from the very beginning. And all we're saying is state and local should be doing the same thing. And this bill, this bill really doesn't really cost a lot. I don't see really it costing a lot. It's just really, it's more of a education piece. Telling people, don't be afraid to come forward. You're a law enforcement officer. You'll be able to serve and protect the people. So we need that. We need your voice if you happen to see someone breaking the law on the inside of Rankin Fowler or on the outside of Rankin Fowler.
Thank you very much.
Thank you, Mr. Chair. Just as Delegate Smith had mentioned, we had a bill come up regarding state contracts, and I signed on and supported that, and don't know why I would not want to be supportive of a bill like this. What I'm surprised at is that, and I'm curious to know, did any government agencies, any police agencies ask to be, I guess, to testify in support of this legislation?
Not that I'm aware of.
I could see where it could save governments an awful lot of money, and if one wants to protect the government coffers, especially in Baltimore City, for being sued as it has been, you would hope that they'd have people who are willing to essentially put their lives on the line, because as this gentleman spoke, if an officer doesn't provide you backup, it could leave you in a real precarious position where you could end up dead.
That's right.
So no government agencies asked to support this, and as Mr. Delegate Smith said, this isn't a novelty. Thank you.
Actually, Mr. Smith, just a quick little follow-up on that. If you recall, New York police recently, everybody heard about, when the guy from Maryland went up and shot and killed 2 police officers. Now, everybody saw across the world, these officers turned their back on the commander-in-chief. It wasn't all of them, but it was a significant number.
So if they're willing to do that to him, why would they not be willing to do it to a whistleblower?
And that was the message that I was hoping that the American public would get now. That was, if they will do in uniform, turn their back on the commander-in-chief in front of everybody, and do it not once, but several times. Imagine what they will do if another officer decides to speak out against what they want to do. Sure, you turn around, they're not there, man.
And officer, I don't know your name, but you had
Matthew Fogg.
Mr. Matthews Fogg?
Matthew Fogg.
You mentioned a class action lawsuit.
That's correct.
Could you please tell me what the name of that lawsuit?
Yeah, it was Fogg. It started off with Fogg v. Reno, and it ended up probably with about 8 or 9 other attorney generals by the time we got to the end of it. I won the case in 1998 in U.S. District Court in Washington, D.C. 13 out of 14 of my civil rights were validated according to federal jury. And then in 2008, they ended up finally paying me. So it took 10 years of appeals of the same Department of Justice fighting it. And then what we did, now I'm the class agent in a class action representing hundreds of black U.S. Marshals around the country, all saying the same thing. So what we're just simply saying is, if it's happening to us, it's translating to the street. It's translating. If I'm concerned with a bigot with a badge or somebody working next to me, you know what you're going to do to the public.
Thank you.
I apologize since I kind of came in a little late, but my question to you, the marshal or former marshal,
yeah.
Were you the only black person that they abandoned? Were they white officers that kind of let you out there on the sea by yourself?
No, I wasn't the only black. There were some. I was the inspector in charge, so they were really going against me. Okay. But there were other officers there, so they were all white. The ones that did it.
The ones that left were all white?
Yeah, the ones that left me were white.
Okay.
Yes.
I guess my question to you, and if you don't know, or you don't want to answer it, or you want to answer offline, is the 800-pound gorilla in the middle of the room race? And basically, is race the primary issue, and then we get down to some of the other stuff below that?
Yes.
Because I think we've all been dancing around it in a lot of different hearings here this session, and with Ferguson and the whole deal.
Right.
And it was. I'll just go back to O.J. Simpson. It just seemed Well, isn't that true? You know, the white folks thought he was guilty, and the black folks thought he was innocent. And then with Ferguson, the black folks still think the officer's guilty, and the white folks think he's been exonerated by the grand jury. And basically we got a real trust perception issue. And a divided community. The Civil War is still here.
Delegate McComas, I would just say this to you. I was just on CNN debating a white officer out of New York on the Eric Gardner killing. Now, we all understand that the New York Police Department had outlawed the chokehold. We understood that. And they outlawed it for the very reason that some people say, why don't the officer just shoot him in the arm or shoot him in the leg? And we understand that that's deadly force. You can't determine where that bullet is going to go. So you can't say, I pulled my gun out just to wound you. I had to fear for my life. Well, the same way the chokehold is, they found out that using that chokehold in a melee or in a situation like that, you could accidentally or you could kill someone. So don't use it unless it is a imminent danger situation. So the same thing with race. I'm sitting there debating an officer who we both saw the same thing with our own eyes, and he's on CNN saying that was just a good takedown. That was a takedown. It wasn't a chokehold. And I'm saying, my lying eyes, we all saw in America that it was a chokehold. And furthermore, even after they choked this man to death and he's telling him he can't breathe, and then after it's done, it's like even the way the EMTs handled it. So what we're seeing across America, and I tell you, yes, race is the most common denominator, if I could use an expression. It is 100% that I've seen across the board. I work with LAPD, Chicago, Miami, because I've worked on Dragnets as a U.S. Marshal. I've been on a DEA task force. I've been cross-designated as a DEA agent. I saw how we were told, don't go into the white area, just stay more or less to the culturally black areas, or what we call the easy kills, to go after them, because we knew they didn't have the power and the resources to fight us back. So if you be like my special agent in charge said, Fogg, if you go into those areas, see, he didn't even see the racial issue of it. All he was saying is, you go into those areas, those folks know lawyers, they know judges, they know politicians. We start locking them up and their kids, we're going to get a phone call and they're going to shut our operation down. He said, Fogg, just go to the weakest link. And I said, man, that's ethnic cleansing. Because basically the weakest link turned out to be people of color. Now we look at all of the numbers that the ACLU and Amnesty International, all the reports that are reporting, they're coming out and they're saying, I would have to say two things. When I look at the disparities in the reports, I say either black people are criminal-minded people or somebody is targeting them in a specific way that makes it look like they're more apt to commit crimes, violate the drug laws and everything else. So yes, your answer is, it is 100% that I've been able to see that race does play an important role.
If I could just also respond. Furnished in the packet that I left with the delegates is an Exhibit A. I like to use material facts to show exactly what the environment looks like. This is when you see Exhibit A, it may not be here today, but you do have it. Exhibit A sucks the air out of the room, and it shows clearly the custom, practice, culture, the acceptance of racism, discrimination under the color of law. This officer that's testifying in Exhibit A, towards the end of his testimony, he admits under oath that he was told from the time that he entered law enforcement to keep his mouth shut when he saw things. And at the same time, he says under oath he would never talk. Those are admissions. My lawsuit for the FCA is Ken Williams, United States Ken Williams versus the City of Brockton, if you want to look it up. And in that particular lawsuit, you'll see what I'm experiencing in my jurisdiction, and it's no different than what's going on down here.
That's right.
Thank you, Mr. Chairman, and thank you all for testifying today. Delegate Carter, would this be model legislation, or have other states grappled with this? Because I wonder if this could be model language to be used in collective bargaining negotiations, because we have to deal with the FOP and.
Well, I'd like to say it's a model. It could be a model. It certainly, I think, would be useful. But no,
absolutely. I mean, I think
I've said it actually was derived from legislation in another state.
Okay. Because out of all the bills that we've been, reviewing, I mean, this would be a moderate one. I think that for the reasons that you guys have argued today, I think it would be a responsible move from the General Assembly of Maryland. Thank you.
I guess just following up, Delegate Smith, Delegate Morales, thank you for being here too and traveling on this important issue. I guess for the ACLU, we've been asking several people clearly interested in, where the language came from and is it model-like. So my question is, in being here today to support this particular model, has the ACLU reviewed other models that are existing in other states and made a decision that this is the better one, or testifying in support of this bill because it's here? So has the ACLU undertaken kind of a review of what is out there and what can be beneficial? And is this the best one?
I have not undertaken a comprehensive review as to all of the other whistleblower laws that are out there.
Okay. And then my second question is, in terms of how this works, in section 3-803A on page 3, that's what the action is if the officer discloses evidence that he reasonably believes, just take, for example, a substantial and specific danger to public health or safety. Then is there any limit on the time frame then upon which a retaliatory action, because retaliatory action can be defined as a change in their status. So say it was like 10 years later, the disclosure is made under 3-803A, and then there's an action to the officer, how many years later? Is there any statute of limitations or time frame, or you can reach back as far as you want and use?
You have state law, you have federal law, and under the federal law, the EEOC makes it clear, as well as the state law, that the time that the person recognizes as a potential victim that they are being victimized under the discrimination umbrella, the clock starts to tick. And under the state and federal law, if you don't dual file an EEOC claim, you have 180 days, I believe, under the state of Maryland. If you do dual file, you have 300 days to come forward to the EEOC, file a complaint, get your right to sue letter, and then file a formal complaint of civil action and, as a lawsuit. So that would be probably your statute of limitations.
So there's some reasonable nexus there between, there's intended. You're intending there's a reasonable nexus between the time that the disclosure's made and an action's taken against you. So the other question, this is purely because I think I'm just exhausted. Can't do the analysis. On page 3 in lines 16 through 18, it says, subsection A of this section applies to a disclosure that is otherwise prohibited by law or a disclosure of information that is confidential by law. So what are those disclosures? So this is only applying to a disclosure that's otherwise prohibited by law or a disclosure of information that is confidential by law only if the disclosure is made, and then it sets out the process upon which you have to make it, but I can't wrap my hands around what that means.
There are certain offenses that are private. For instance, if it were a rape, if it were a sexual assault by an officer against another victim, could be a fellow officer, could be a citizen. Those are going to have privacy issues that full disclosure can't be made.
So are they prohibited by law or they're confidential by law? I'm thinking if you say by law that it might be too limiting, but okay, so that's what you're envisioning by those are the disclosures that are protected? Okay, and then my last question is, here in this state, because I know if there's opposition, it's coming behind you, so I'm trying to ask the questions ahead of time, is we have this LEOBR that was put into place in Maryland that's supposed to help protect officers, and it gives them the right to this a hearing before any disciplinary action. So in the states in which you've had issues, were there any LEOBR procedures in place to protect?
See, what you're discussing right now is after a person is now aware of the fact that they have an issue, they have a property right interest in their job, There's what's given under due process. The 14th Amendment affords notice, grievance, and the process after you're given notice that there's adverse action coming your way in a grievance type of setting. You have an arbitrator. If that doesn't settle the issue, you can also file a civil action. So the way to look at this, the way I like to look at this is at the federal level, you have federal law, state law, and then you have these policies and these the CBA and the MOAs that you make an agreement with officers. Those MOAs and CBAs, they can afford someone some latitude in having some enhanced protections, but you can't lower someone's protections under the ultimate umbrella of the law. So when you make agreements where you're giving someone an enhanced protection, they still can't violate the law.
Right.
Ultimately, if a police officer is violating the law, violating a citizen's rights, violating the Constitution, the federal Constitution, that CBA and that MOA can't exceed the law. Because police officers raise their right hand, take an oath, they're going to uphold the law, they're going to uphold the federal Constitution, and they're going to protect rights.
So I guess what I was asking though was, do you think like our LEOBR would have protected you because before any action could have been taken against you, you would have been granted a hearing here in Maryland?
Right. I mean, the action, Joe Crystal is probably a good example. He's no longer a Baltimore police officer. Did the process protect him in his rights?
Well,
that's up for a jump ball, I guess, in civil proceedings. But ultimately, what I'm trying to say is that under the 14th Amendment, Federal Constitution, 14th Amendment, the 14th Amendment is very clear that you have property interest rights in your job. And that because you have property interest rights, there's certain things that are supposed to flow. You're supposed to be given notice of a possible termination or adverse action to your job. You're also supposed to have certain liberty rights to protect yourself in a grievance hearing to go and protect the job. That proceeding that you're talking about, it may afford some added protections, but sometimes the added protections that are in place really don't afford the employee added protections. It's to protect the institution.
Yes.
Okay. Well, thank you both for traveling here today and sharing this information with us.
This is just a question, and I guess I realize there's this bill, and you think that this might be a small remedy to the problems that we have. The question I have is, do you have any advice as to start chipping away at the bigger picture here? And if you don't want to answer it now, or you want to think about it, you could email Delegate Carter and she could pass it on. I think that the question is we've had a lot of bills and one takes care of this part, but the bottom line is we're not looking at it in a systemic way as to what we can do to move society and the whole issue forward. And before we start ripping everybody apart, which is what I'm afraid we're going to go down that road here.
Well, I don't necessarily, and I understand, Delegate, what you're saying is, but I think, there's always this thing that change is going to sometimes cause a little heartburn, especially when you've been pretty much seated and doing things a certain way. What I found out with law enforcement is we have a tendency to become this sort of monolithic sort of society where we begin to really set our own rules and regulations. We begin to, instead of us working to serve and protect the people, all of a sudden we're the ones setting the laws and the policies and the procedures.
It happens here too.
Yeah, exactly. And but when it happens in law enforcement, like I tell people, some people say, well, you got a few bad apples. I said, let me tell you something. In law enforcement, you can't have a few bad apples. Because a few bad apples, that's like somebody saying you got a stadium full of people and they come over the microphone and say, listen, everybody in the stadium is good, but we got 2 bad apples in here and we don't know what they're going to do. I guarantee everybody going to go home. Because the bottom line is we have the means and the ways of hurting people. So what we're just simply saying is, yes, that even something as simple as this bill, what it does to law enforcement people, it tells them, listen, it's time we change this culture so we go back to where we are. We have community policing, not policing, telling people what to do with us. But the bottom line is, we're back to saying, how do we bring this business gap? This is a lightweight deal. It's just simply telling law enforcement officers, you got rights, don't be afraid, come forward. This is important, we gotta have this. If that's a start, there's a whole lot more needs to be done. But this is one small start that I believe can really help to change the paradigm.
I just want to add to that. Deputy Chief Fogg was at the federal level. I was at the local level. You're looking at people that were the system. We upheld the Constitution. We protected rights. When the system is two different systems for two different groups of people, the system's broken. I can tell you as an insider, the system has two different types of mechanisms depending on who you are, what you look like. As Deputy Fogg said, his directive was, don't go in that other community using the tactics that we use in this community, or we're going to have some folks fired. We're going to have some folks receiving complaints from folks that have deep pockets that can hire a lawyer. You can't have that because that's called discrimination. Justice Louis Brandeis, quote, "At the foundation of our civil liberties lies the principle that denies to government officials an exceptional position before the law in which subjects them to the same rules of conduct that are commands to the citizens." You can't have two different rules just because a cop is a cop. Cop is citizen on patrol. The people pay the salaries of those cops. The people grant those cops their authority. The cops work for the people. The people don't work for the cops. That's the problem here. And it's important that police officers realize that if they work in a depressed community, like let's say for instance, I'm not sure what the economics are in Baltimore, but if the average officer is making six figures, enjoying overtime, and has a great life, they have to realize that it is the taxpayers that are affording that salary, that great life. And they have to go and treat them with respect and dignity. If you have someone that breaks the law, I had a guy that tried to run me down and kill me in the road one night. I had to shoot him. But I still ran up to the car after I shot him and gave him first aid. You have to have empathy. You have to have respect for another person's life. You can't have it where it's this us versus them mentality. Because last time I checked, police officers aren't from Mars. They're from planet Earth. They're from the very neighborhoods that they police and patrol. Well, so in society, it's important for police officers to come off their high horse and recognize that they are breaking the law themselves sometimes, but they get away with it. Have some empathy for others.
And Delegate McComas, if I might just add, it is a big issue, but there's no one bill that's going to solve it. But the flip side of that is that nothing is not an option. There are things that have been brought before you that will make a difference, that will help move down the road to better relationships between communities and police. Will they solve everything? No. But will they send a clear message that this is where we need to go, that we value both the community voices and the law enforcement voices? Absolutely. Absolutely.
Mr. Chair. Sandy. Thank you, Mr. Chair. Delegate Carter, this is for you. While I was sitting here, I did a whistleblower search on the statutes, and it came up with, under the State Personnel and Pensions Article 5-310, why isn't this adequate enough? Why do we have to separate the police officers out separate?
And wouldn't it be better if we were really trying to do this for all state employees? Why wouldn't we try to amend this article instead?
Well, I think that we've heard consistently this session in various different measures that law enforcement is treated differently.
But shouldn't we look at 5310 where it applies to all of the employees, and if we want to carve something out, apply it under there instead of in public safety?
Well, I guess that's certainly an option, but I think that the important thing is that we listen to the gravity of the problem and really provide a meaningful fix to the problem.
Okay, thank you very much.
Are there any other questions? Thank you very much to the panel. Are there witnesses in opposition to the bill? Please come forward.
Thank you.
Thank you.
Good afternoon, ladies and gentlemen of the committee. My name is Chief Mike Scott. I'm the Chief of the Mount Rainier Police Department, Mount Rainier, Maryland. I'm here representing the Prince George's Chiefs Association, the Maryland Chiefs Association, and the Maryland Sheriff's Association in opposition to House Bill 1187. The testimony that you just heard from my brother officers, there's not a lot I can disagree with. I agree with basically everything that they said except for their support for this bill. And there's 4 basic reasons why we do that. First of all, I'd like to say that from an integrity standpoint, at least in my department and the departments with which I am familiar, one of my first general orders in my manual that tells my officers how they do their job is a requirement that they report misconduct. We have a general order, very short and very specific, that says we do not tolerate lying, cheating, or stealing, or anybody that does that. And it's the duty and responsibility of every officer in my agency to support that and to make those reports and to point out that misconduct from us. As delegates already pointed out, we are already entitled to a hearing under the Law Enforcement Officers' Bill of Rights before any disciplinary action can be taken. And that disciplinary action is transfer, demotion, transfer to a different assignment. That law is already in place to protect officers that come forward to report misconduct. State law enforcement officers, all law enforcement in the state, are already covered by Whistleblower Act, not only from the state of Maryland, but also in the federal area. If you take a look at the fiscal report on this, in 2014, only nine whistleblower complaints were reported in the state of Maryland, none of which involved a law enforcement officer. So we're asking ourselves, why are we being targeted here outside of this law, and why are we trying to create a special law just for law enforcement officers? And the last one, it's the most troubling to me as a chief of police, is the fact that this would limit our ability to discipline officers who report misconduct that they are a part of. So if they are a part of a scheme to defraud the department out of money or property or things like that, they have a second thought, and they report as a whistleblower their fellow officers. It would be almost impossible for us to discipline that reporting officer, and they would be held not accountable. So as in my last point, just I know we're pressed for time, is that this bill, as we look at it here, it would prevent superior officers, chiefs of police, supervisors, and other higher-ranking officers from taking adverse actions against officers who report misconduct. This does not control the behavior of the officers' peers. It doesn't at all address what happens with their fellow squad mates, their fellow investigators, and the other people who which they are involved. And so for all of those reasons, the chiefs, the sheriffs, and the Prince George's chiefs all would urge you an unfavorable report on House Bill 1187. Thank you.
Good afternoon. Karen Kruger. I serve as general counsel to the 3 associations that Chief Scott also represents. There are 3 reasons why this bill should receive an unfavorable report. The first is that under Maryland law, as Chief Scott and Delegate Valentino Smith have mentioned, the LEOBR provides a forum in which an officer can raise a claim of retaliation as to the merits of a disciplinary action. But let me also draw your attention to Section 3-103D of the Law Enforcement Officers' Bill of Rights, which says, A law enforcement officer may not be discharged, disciplined, demoted, denied promotion, transfer, or reassignment, or otherwise discriminated against in regard to the law enforcement officer's employment, or be threatened with this treatment because the law enforcement officer has exercised or demanded the rights granted by the subtitle or has lawfully exercised constitutional rights. There's an anti-retaliation provision already in Maryland law. And as is obvious from the testimony of the proponents of this bill, they were not familiar with Maryland law. They did not bring you anecdotal evidence from Maryland law enforcement officers. There are no Maryland law enforcement officers here today testifying in support of this bill. That's the first reason why it should receive an unfavorable report. Secondly, I spent, along with Ms. Love and Chief Scott and many people, spent many hours with you last Thursday going over those proposals relating to the law enforcement officer's Bill of Rights. And now, ironically enough, we see this bill, which actually creates a shield for officers who are trying to evade discipline. This bill, because of the way it is structured, particularly legally, and it's been pointed out about these specific burdens of proof, that's one problem. These are egregious burdens of proof, very unusual in statutory language, that an agency should have to prove by clear and convincing evidence an allegation for which the proof can be very light, quite frankly, will be very burdensome on agencies, will have a significant chilling effect on chiefs and sheriffs in imposing discipline, and will create an avenue for officers to, with merit or without merit, claim that they have whistleblower protection just to further delay the disciplinary process and possibly collect damages against the agency. This is bad public policy. So thirdly, I ask you to give this bill an unfavorable review because it flies in the face of everything you were trying to accomplish last week with the LEOBR bills. And I have to say that those, as a group now, we see the full package, and this package of bills are ill-conceived, based on misapprehensions of what the existing law is. They are internally contradictory. They contradict with each other, which causes me to implore you once again to reject all of these bills out of hand. Unfortunately, no subject matter experts were consulted in the drafting of any of these bills. And what they've succeeded in doing is, and I look particularly to House Bill 968, you're denying due process rights to the officers and at the same time hampering a chief or sheriff's ability to impose discipline. And the bill before you today will go a long way toward hampering those. Just as a last point, I noticed Delegate Valentino Smith picked up something very significant in that this bill is so flawed that it doesn't even make a temporal connection between when the law enforcement agency action might occur and when the supposed disclosure occurred. So someone could be transferred 10 years after having made a supposed protected disclosure and will have now these legal rights to essentially sue the department. And how can a chief or sheriff manage an agency with that sort of rubric hanging over his head? It's totally unreasonable, and we ask for an unfavorable report.
Thank you. Mr. Chair, you bring up on a point that started to make me think about, what you said about you can't go after the person, the whistleblower. So an officer finds out that there may be an investigation coming up, and he blows the whistle on himself. You then can't prosecute. The way you read this bill, you couldn't then prosecute him under, the whistleblower because he did actually blow the whistle, but he blew it on himself. That's the way I'm reading, and that's the way our counsel reads at Section 3-803. If the officer comes forward and he's been a participant, in other words, he discloses information about himself that I participated in a theft or whatever it was, or a beat down of a gentleman on the side of the street, I'm now the whistleblower, and under Section A1 and then I2 and 3, I would find it very, very difficult to be able to prosecute him for that because this law prohibits me taking any retaliatory action against him for coming forward with that information.
Right. And there's no other recourse. Look, as a supervisor, there was a lot of guys that, I expected them to do their job. But I mean, they could have made things up and, about me, and I had no recourse at all. I mean, they had to continue working for me. I couldn't, under this, you can't transfer him, you can't do this with him, you can't do that with, you can't do anything. So he's really there working for me, even though it's bogus. And at the end of the day, the way I read it, the only thing that if you prove that it was false, there's only reasonable attorney fees and litigation expenses. There's nothing in here that says how we can punish that officer for making those bogus complaints about you. Even
though that would be a false statement that typically would be punished, I think you're right, Delegate Cluster, that this will tie the chief's hands. I mean, that would be a retaliation on top of retaliation.
Exactly. Yeah.
Any agency lawyer is going to say, "Don't go there, chief."
Right. Okay. Thank you, Mr. Chairman.
Thank you, Madam Chair. I agree with everything you said about whistleblower statutes, but they're everywhere. There are a great many agencies and whatnot that have to deal with a whistleblower statute. I used to practice labor law, and I thought it was really annoying because sometimes people misuse that law. But my question is, if this isn't the right bill, hearing the testimony from the people who came and just the sort of generic understanding or possibly misunderstanding that police do really protect their own more so than most other groups, and to the point where it seems to me that may be one of the real issues that is helping to perpetuate this police versus citizens, because there isn't a forum for identifying police officers who are acting outside the bounds of what they should be. So I ask you if you have, you may have a very good group of police officers, and I think probably most of them are, but if officers are afraid to step up and at least let you know that something is happening, what is your suggestion for making sure that they have that opportunity without feeling threatened?
Delegate, I think it's an integrity issue that permeates an organization, and that integrity issue has to be started at the top with the police chief and the management of the police department. We have to create that culture through general orders and through training and through interaction with individuals that we expect the integrity to start at the bottom of the organization and work itself through the top. We don't expect the SERP codes anymore. We don't expect those kind of violations because, as I try to explain to my officers, the first oath that you take when you get sworn as a police officer is to obey the Constitution and to support the Constitution of the United States. And that means supporting the constitutional rights of every individual you come across. And that doesn't just mean the traffic violator or the criminal. That means supporting the constitutional rights of every person that you work through. I find it very, very difficult to understand how legislation can improve integrity.
Well,
I think that's an institutional thing.
I would agree with you, but during Governor Ehrlich's administration, I ran the Maryland Transportation Authority, and I set the same tone that you did, but if I didn't have, I use my own auditors, or people who let you know something was going on, I even believe police officers probably do have more integrity than the general population, but all of them are not perfect, and because of these situations that are coming up, just to say that we practice integrity, it leaves something out. There needs to be some way to stop these incidents of people believing in police brutality. Is it not? And for whatever other media is adding to it. And I just wondered if there is anything that you would add to what you and other police officers and commanders are doing.
I think we're doing quite a bit in the modern day, especially considering the atmosphere all across the country. I think we're taking a look at more of how we hire officers and the type of people that we do hire. We're very, very strict on how we do background investigations, and we do everything that we possibly can through psychological evaluations, through polygraphic evaluations, to find the people who have the best chance of being good police officers and without having to go through commit these crimes and do those kind of things. But it's a cultural change that needs to take place within the organization, and I think over the years we've made a tremendous effort in those areas. And do we have a lot of work to do? Yes, absolutely. Do I think this type of legislation does that? I do not. No.
Are you in favor of audio and visual body cameras?
The two greatest inventions for law enforcement in my 40 years are tasers and body-worn cameras. Every officer in this country ought to be wearing one, and every officer in the country ought to be issuing one.
Thank you.
Thank you, Madam Chair. Good afternoon, and glad to meet you, Ms. Kruger.
Yes.
You mentioned that this bill only addressed, I guess, and I don't understand police hierarchy, but essentially the top of the chain rather than squad mates and the like. I'm wondering if the bill were amended to do so, would that help improve the bill?
I don't think so.
Okay. Now, you had also mentioned that there are certain policies and things that are in place. We had a few gentlemen a few days ago testifying about hazing that they go through in the fraternity process. I'm a member of a fraternity. We have our policies as well, but guess what? People are getting their butts whooped against policy, and people are quiet about it. That was their testimony, and they're getting beat. So do you think your policies are enough to warrant or to provide the protection that one officer needs to feel comfortable coming forward when he sees his partner doing wrong?
Delegate Singer, I'm going to answer that in part, and then I will, of course, let Chief Scott answer. But, police officers have a constitutional duty to report the acts of other officers who commit constitutional violations. And they can be held liable under 42 U.S.C. Section 1983 for failing to make those reports. So that duty goes even far beyond any statute that this body might pass. And officers are trained on that. They are trained on that constitutional duty, in addition to their ethical duty that Chief Scott already talked about at the beginning of his testimony.
Now, with that said, would you say that this blue cone of silence is mythical then? Because it's happening. People are, obviously, police officers aren't telling. I mean, I know a few years ago in Baltimore City, it was a big thing with the videos talking about not ratting on one another. And I know it's not something that's just happening on the streets. It's something that obviously is happening within government agencies as the police. I mean, I believe that it's happening.
But we don't know why it's happening. The examples that you give, for people to fail to come forward, we don't know if it's because they're afraid of blowing the whistle, or because they're in a conspiracy with the other people, or because they simply don't want to rat out their friends. So we don't have the empirical evidence that really would lead us to this bill, which at the same time will be extremely burdensome for law enforcement management to take disciplinary action.
Would you tell on your squad car mate, knowing that that person is your sole protector when you're out on the street, because you saw him or her doing something illegal? I mean, at that point, you tell on them, are you comfortable that they really will have your back?
Well, as an attorney, I have the obligation to report the misconduct of other attorneys. And that is not something that's easily done in any profession. That's a very serious matter. And, I'm I am reluctant to report the misconduct of another attorney, initially out of professional courtesy, somewhat out of a fear of being ostracized, somewhat out of a fear of maybe being mistaken. I don't think it's, in that sense, specific to law enforcement. We just happen to be, and it's interesting, too, that we would create this special class of protections just for law enforcement officers when, as has been pointed out by Delegate Ray, there already is a state statute providing adequate protection. This statute goes far beyond anything that I've looked at, local, state, or federal protections for whistleblowers.
Being ostracized or mistaken as an attorney doesn't rise to the same level of having an officer not have your back during a progression of a crime and ending up dead. I mean, you as an attorney, you don't have to worry about ending up dead.
I agree.
Police, they should.
Of course.
But I'm curious from your perspective, rather than an attorney's perspective, a police officer, are you going to squeal on your mate?
Maybe not the first time.
Okay, that's fine.
But let me tell you, let me make sure that you understand this. Is that the person that has my back also has to know that I have theirs.
Right.
And there has to be that trust level there.
Right.
And it's happened to me on several occasions during my career where I've had to take a fellow officer aside and basically take him by the buttonhole and say, if you ever do that again, I'm going to be working here and you're going to be working somewhere else. Because there's just certain behaviors you don't tolerate.
Right.
And that has pervaded the organization that I retired from, the Park Police of Montgomery County. That mindset pervaded that organization, and it helped me to better supervise and to develop policies for the people that I supervise now as a chief of police, because it's an integrity issue. And my job as a police chief is to make sure that that integrity is maintained all the way to the lowest level, to the newly hired officer that we have. And that's my responsibility. And I can tell you over 40 years, that blue line of silence, that code of silence, is not like it used to be. It's not. Because of the type of people that we hire, the backgrounds that we put them through, and the training that we give them. And at least in my department, every officer that comes to work for me gets about an hour talk about what is expected of them. And they are told straight up, so we do not tolerate lying, cheating, or anybody who does.
And the thing that I love about these public hearings is it gives us an opportunity to figure out how to make things better. You had mentioned that the way this bill is currently written, that it might protect a whistleblower who actually happened to be a part of the scheme. And in fact, I think something similar to that was mentioned on the bill, the False Claims Act. So I believe that was addressed in that bill and could be addressed in this bill. You certainly don't want a wrongdoer getting off and benefiting from something so that could probably be checked to make this bill better. But the whole temporal connection, that's something else that could probably strengthen this bill. But my last question is, you said the LEOBR already has these protections, so we don't need this. This bill would be redundant. So again, my question then would be, is why do officers feel unsafe telling on one another if they feel that this protection is already there?
Well, we don't have any empirical evidence before us today that indicates they do feel unsafe. There was not a single Maryland officer came here to testify in support of this bill.
But that was a testimony of the prior witness.
They were not employed by Maryland law enforcement agencies.
Right, but they were law enforcement, so
yes.
We can't say that that does not exist. Again, my uncle was a Baltimore City homicide detective. So he shared plenty of stories of things that happened to him when he was on the police force. And not attributing in what I'm saying to him, but the fact of the matter is, if you tell on people, again, if you tell on the people that are closest to you, they may not have your back at the most inopportune time, and you could end up dead. So, I mean, this is something to me that not only seems to protect the general public, but it protects good officers that are trying to do the right thing to make certain that the department and their colleagues are doing what they should be doing, which then in turn helps the government so that you're not ending up like Baltimore City paying out all this exorbitant amount of wasteful taxpayers' money because you have to defend stupid lawsuits. That's all. Thank you.
Madam Chair.
Any other questions for this panel? Not, I think that.
Thank you all.
Okay, and the committee can hang on for a second.